Welcome back to UPC Insights, the podcast where we decode the latest trends and decisions in the world of European patent litigation. I'm your host, George Walden. Glad to have you guys here. In today's episode, we're taking a closer look at a tool that often works behind the scenes, but can have a huge impact on litigation strategy. It's called protective letters. Why are more companies now filing them? What's the court's practice so far? And how can this defensive measure influence preliminary injunction proceedings before the UPC? To answer these questions, I'm joined once again by Jasper Werhahn and Tilman Pfrang, both UPC representatives at Meissner Bolte. Jasper, Tilman, great to have you guys back after 2 weeks, and let's get to it. What is a protective letter? So, Tilman, let's start simple. For those listening who are less familiar, what exactly is a protective letter, and why would a company want to file one at the UPC?
Yeah, George, you recall last time when we talked about ex parte preliminary injunctions.
Mm-hmm.
So what is an ex parte preliminary injunction? You file a request for a preliminary injunction, and you request also that this is granted without even hearing the party.
Ooh.
If the court acts in that way, so grants the preliminary injunction without hearing the party, we are talking about an ex parte preliminary injunction. And our topic of today is protective letters.
Mm-hmm.
And protective letters are explicitly, I would say, invented a long time ago for that reason, namely to avoid, from the perspective of the potential infringer, to avoid an ex parte preliminary injunction. The main goal is not to defend against the injunction as such. The first step is that you want to achieve with your protective letter is to get the chance to even discuss the case with the court and have your right to be heard fulfilled. Therefore, what is a protective letter? It's a letter to the court where you proactively present arguments that you do not infringe and or that the patent is not valid and or that there are other reasons why a preliminary injunction should not be granted, or at least that you should be explicitly heard by the court.
So, timing and strategic use. Jasper, when should a company consider filing a protective letter, and what kind of circumstances should trigger this?
Anything that makes you suspicious of a competitor that to potentially apply provisional measures against you should be a reason to file a protective letter. There is a few standard scenarios that come to mind. The most obvious one being a competitor directly threatening you with a warning letter or a request for entitlement saying, look, we have a patent, you have a product, we think you do infringe, please let us know why you think you do not infringe. In this scenario, it's quite obvious that somebody is about to pull you before the court, and in such cases, it's a very wise decision to file a protective letter as a first measure, as Tilman has just explained. Typical trigger for such situations are trade fairs and exhibitions as well. If you go to an exhibition and you have been in conflict with a competitor and you have a product that you think may somehow touch upon one of his intellectual property rights, this is also a good time to file a protective letter, because as we have seen from the UPC, during trade fairs, they like to hand out preliminary injunctions pretty quickly. We have seen decisions where the granting of the preliminary injunction at a trade fair took only a day. So better be prepared for this situation, I would say. Yeah. Also, many people, many of our clients, and we do strongly advise this, have a patent monitoring system. They check the market for potentially relevant patents. If you see a competitor that is about to get a patent granted that could be of relevance, this would also be a good time to file a protective letter, in my opinion. Typical situation also, George, which is often overlooked when people monitor the patent market of their competitors. Mm-hmm. Imagine you have a very complex product and your competitor gets a patent granted for a method to manufacture the product. Mm-hmm. Oftentimes, it's not possible from the product itself to understand how it was manufactured. So at first sight, you could say, well, this is not a relevant patent because how would he ever prove infringement? However, we know that the UPC has the measure of inspection proceedings. So a patent owner that has a patented method for producing a product and that has difficulties to obtain the required evidence for infringement can apply for inspection proceedings. This means that somebody will enter your firm and will check your machinery and will check how you actually produce your products. So if such a patent gets granted by one of your most fiat competitors, it's also a good time to file a protective letter against such claims to make sure that you are being heard before such provisional measures are applied.
Definitely. So what should a good protective letter contain? So Jasper, from your experience, what are the key elements that make a protective letter effective before the UPC?
Yeah, anything that makes the court reconsider the PI application is, of course, valuable. And three main arguments come to mind that should be contained in every proper protective letter as far as they are applicable. The best argument you have is non-infringement. If there is any good argument to say the infringement is not more probable than improbable, if you can somehow convince the court that the probability of infringement is below 50%, then you're off the radar anyways. So non-infringement arguments should be your first shot in the protective letter. Second shot, validity of the patent at issue. Do you have good prior art that was not considered in the examination proceedings or in potential opposition proceedings before the EPO? If you have such prior art, you should present it. And for this, it's very important to present your validity attack in a very clear and straightforward way. Ideally, you go through the claim feature by feature and really lay out in detail why you think this is disclosed in the prior art that you have available, because you have to put yourself in the shoes of the court that has to decide on a preliminary injunction there and a time pressure. So your arguments have to be curt, concise, to the point, and very, very clear. And also, don't bombard the court with 10 documents for lack of novelty. Choose your best shots and put them in the protective letter. And finally, one further argument that we have seen to be very successful is the urgency discussion. Can you somehow make it clear to the court that the potential PI applicant has known that you have been producing this product for a long time? If you have such evidence available, you can take away the urgency of the whole request. Wow. And this is also a very easy way to overturn a PI application. So to sum up, three main arguments should be contained if you have good arguments available: non-infringement, non-validity of the patent issue, and lack of urgency.
Sure, very sure. Early case law and court practice. Tilman, how have the local divisions of UPC been dealing with protective letters so far? And have you seen any procedural trends or notable cases?
Yeah, well, there have been some cases. You may recall last time when we talked about preliminary injunctions in general, and there we mentioned also the local division in Düsseldorf again, which is rather willing, apparently, to also grant ex parte injunctions. And there have been two very interesting cases. The first one is Maestroma versus Revolt Cycling. And there was a rather brief protective letter with arguments relating to exhaustion and also some arguments relating to infringement. However, no arguments at all related to the validity of the patent. Then the Düsseldorf division granted the ex parte injunction because they said, well, the exhaustion and infringement arguments are just not convincing, and the potential infringer or the defendant in the PI proceedings did not present any validity arguments, none at all. And therefore, they considered the patent valid without any further investigation. And this is important to know. Normally, the criterion is, as Jasper has said, below 50% validity, and you win the case as defendant. However, if you do not present any arguments, the court will not even look into this in detail.
Wow.
At least if there is a high risk as on a trade fair or so on, and the ex parte injunction is on the table. And then they will not even have a further look, and the ex parte injunction will be granted if infringement is more or less confirmed. And another very interesting case, also Düsseldorf local division, there actually wasn't a protective letter. But also that case is very interesting because it highlighted the relevance of your reaction to any warning letter. So the defendant in that case received a warning letter and also responded thereto. But this response was also presented to the court by the applicant for the preliminary injunction. However, they said, well, the response to the warning letter was considered, but we do not find it convincing, and also no protective letter was filed. They explicitly mentioned this. And therefore, and for some other reasons, they granted the ex parte injunction. So in that case, maybe a protective letter would have been a good idea.
I think so. Procedural and transparency in publication. Tilman, let's talk about confidentiality and transparency. Protective letters are accessible in the CMS, right? So does this raise strategic concerns, for instance, revealing a potential infringement risk to competitors?
Your protective letters are not from the beginning accessible to the in the CMS. So in general, this is not entirely correct. The protective letters will be kept secret by the court, actually. So no one can see it until the time, but this time is not in your hands, until the time that any ex parte PI request is filed. In this moment, the protective letter will be sent to the applicant for the PI. And also, in principle, from that moment on, your protective letter can be accessed via the CMS. However, only upon request by the third party who is interested in the proceedings. And it's far from certain that during pending proceedings, this request is granted. So there's a certain protection. Usually the courts say, well, during pending proceedings, we do not provide any information or any submissions. There are also exceptions to that. In any event, let's assume in your protective letter is any secret information, then there are potential measures or rule in the rules of procedure which should be considered and should be taken, namely to request that either your secrecy should be kept away from the general public, or even that you request something like that only a very restricted circle, maybe the attorneys, the representatives of the other party can have access to this information in an extreme case. So you are not without any protection regarding your trade secrets and so on, but you must actively request these, and you can of course do this also when filing your protective letter, so from the very beginning.
So is this protective letter like kind of like a wild card, get out of jail card kind of, is this like a surprise card, like gotcha, as far as, to the patentee or to the infringer, or is that what that is in a nutshell?
It's something you have, well, let's say in your hands, or no one knows about it until the PI request is filed, definitely. So it's kind of a wild card. Yeah.
Okay, so duration and validity of protective letters. Jasper, how long does a protective letter stay valid? And what happens if no PI application is filed within that time?
So according to the rules of procedure, protective letter stays valid for 6 months from the time of receipt at the register of the UPC. So it's kept in the register for 6 months. After that, it's removed from the register. However, it's possible to extend your protective letter before expiry of this period of 6 months by paying a very low extension fee of, I think, 100 euros to the UPC, and then it will be renewed for another 6 months.
Oh, okay. Then cross-border effects and forum shopping. Jasper, does the availability of protective letters influence where patentees file their PI requests? And are we seeing signs of division shopping based on how protective letters are handled?
That's an interesting question. From what I have seen so far, I cannot recognize any trend or effect that the filing of protective letters would have on the forum choice. And to be honest, it's also very difficult to assess this question because, as Tilman has said, the protective letters are hidden. They only pop up when a PI is filed, a PI application is filed. So it's a little bit like vaccination, it's the prevention effect. If it works, you won't hear about it. So no idea whether there is any effect on the choice of forum. Of course, you can take into account the fact that, for example, Italy on a national level does not know the system of protective letters. So if you were very worried about a protective letter as a potential PI requester, you could think about going to a local division in Italy because they usually don't handle protective letters on the national level. Nevertheless, they will be confronted with the arguments in the protective letter, and the rules of procedure are very clear on how the court has to apply the arguments in the protective letter. So I don't think that there is a direct influence of the protective letters on the forum shopping.
So you're saying you might go to Italy, the court in Italy, just to go outside the normal rules that normally apply, whereas you
you would then be faced with a division composed of at least some Italian judges that have no prior experience on the handling of protective letters. But if this is really a valuable strategic option to draw, I'm not sure.
Okay.
I wouldn't make it dependent on this question.
Maybe a comment to that.
Okay.
If you're talking about UPC protective letters, you should, of course, also consider that at any time, at least for the next 5.5 years, also the owners of European patents can go nationally. And Italy, I have learned right now, does not know the concept of protective letters, but many other jurisdictions do. Germany, Netherlands, I think also Spain, I think also France. So many countries know the concept of protective letters. And therefore, I would recommend that if one of those jurisdictions is an issue, for example, Germany, that you do not only provide a protective letter at the UPC, but also at the German protective letter system.
Yeah, that's a really good point that Tilman has. For the traditional EP patents, you still have the choice whether you want to enforce them before the UPC or on a national level. So that's a very valuable input from Tilman. If you are located in Germany and you're concerned about infringement in Germany, you can be attacked two ways, either via the UPC or via German National Court. And when you have already made the effort to prepare the protective letter, do file it both with the German system as well as with the UPC, so you're protected before both venues.
Interesting. Potential risks or downsides. Tilman, are there any strategic risks in filing a protective letter, and could it backfire or create procedural disadvantages?
It could well backfire, and I think one case we mentioned already where there was a protective letter even, but that did not explain anything in relation to validity, and also as far as I've heard, the arguments with respect to infringement and exhaustion were not that comprehensive, maybe in the end. In such case, yes, actually, I see the risk that it would have been better to not file a protective letter than to file a protective letter. If you miss certain points in your protective letter, then the court will say, well, obviously there is no counter argument, but maybe there is, but you did not bring it. And if you do not find any protective letter, they are kind of uncertain. They don't know, is there a counter argument relating to the assumption of validity, or is there no counter argument? And so, in short, yes. The problem, of course, is, and this is so difficult, and in the end, for the potential infringer, of course, you do not want to provide any information which the potential claimant, the patentee, does not already have. You know, for example, you don't know what acts of infringement are alleged in the end. So you must anticipate certain things and then bring your counter arguments. And this is very difficult. So in a certain way, you want to say as little as possible. But on the other hand, saying too little is very dangerous. So it's a very delicate tool, the protective letters, and you should really make your mind up what information to provide and what you better keep secret.
Right. Jasper, do you have anything to add to that, or you?
Yeah, there's one formal aspect that I would like to add. The rules of procedure stipulate that when filing a protective letter, you have to indicate the name of the presumed applicant for provisional measures. If you have a patent that is granted to competitor A, it's quite easy to say, well, the presumed applicant for this preliminary injunction will be the patent proprietor, that is person A, with the full address. However, under the UPC agreement, also licensees are entitled to sue out of patents. So you really have to make sure that if you want to bring the effect of the protective letter to full extent, that you really incorporate each and every single company that might somehow be affiliated with this potential patent issue. It's not only the patent proprietor, it could also be a subdivision of the company. It could be a known licensee of the patent proprietor that is known to have licenses for patents of this proprietor. So make sure that when you file your protective letter, it's totally fine to include a list of, say, 20 potential applicants for the protective letter, for the preliminary injunction, but make sure you don't miss anybody, because otherwise the protective letter cannot be assigned to the case, because how would that work, right? You have a new PI request coming in, they check who is the applicant for the provisional measure, then they counter check, is there any protective letter in this regard? And if they overlook something, then you might be you might have a problem. So make sure you really put down all the potential applicants for the preliminary injunction in your protective letter.
Interesting.
One.
That brings us to the end of today's episode on protective letters before the UPC. Jasper, Tilman, thank you once again for your clear and practical insights. It's clear that this defensive tool, while procedural in nature, can play a key role in strategic chess games of UPC litigations. And I'm looking forward to hearing maybe you guys taking cases to Italy in the future. That'll be interesting. To our listeners, we hope you find this discussion helpful. If you did, please subscribe to the UPC.Insights, share it with your colleagues, and leave us a rating. And if there's a topic you'd like to discuss or for us to cover in the future episode, then let us know via our website. Until next time, I'm George Walden on behalf of Jasper Werhahn and Tilman Pfrang. We'll see you soon and stay well und auf Wiedersehen.
Auf Wiedersehen.
Auf Wiedersehen.